So the topic today is a very personal one for me, and that is for a few reasons. The topic at hand is give your rabbi a tax break. So this is personal for me, number one, because I am a rabbi and I pay taxes. And number two, also because in a past life, I did work in the accounting field, and I do have an accounting background, and therefore I just find the whole topic very intriguing. That being said, I'm going to make a few decisions, I guess, or conclusions in today's lecture regarding tax law, but please don't operate solely based on what I say in this lecture. If you do have a client who is a rabbi or a clergy member, and if you are not sure whether they merit a tax deduction on their return, please either consult your supervisor or use your own opinion if you're qualified, or consult your local accountants, but please do not rely solely on what I say today. So the topic at hand, what I'd like to do today is 3 steps. The first step is to generally investigate in Canadian tax law the background of let me just note that I'm going to mute everyone now, but if you do want to speak up, please do. You can mute yourselves and participate anytime. So the first thing I like to do is, again, investigate the Canadian tax law in determining who is a member of the clergy such that they qualify for a deduction on their taxes. Secondly, what I'd like to do is compare the tax exemption for members of the clergy in secular law to the tax exemption for quote-unquote rabbis in Talmudic law. There is also an exemption for rabbis in Talmudic law, but although it sounds similar, I think what we'll see through our study today is that they are different both in terms of their scope and in terms of their character. And then finally, through that analysis, I hope to shed light on a particular case in court, and I want to thank Miriam Snowbell and Jeffrey Silver for bringing this to my attention. A very interesting case in which a number of rabbis tried to claim the tax exemption and were denied that exemption by the court. And I actually think that their argument is very much rooted in their understanding of the Talmudic sort of idea of what a rabbi is, what Torah is, and what a tax exemption for rabbis would be. So let's begin with the secular law. I am going to share the source sheet in the chat. I'd rather do that than share my screen. So please, if you don't see it in the chat right now, please speak up. And if necessary, I will share my screen. But I'm going to assume that everybody sees it in the chat and therefore can follow along. Okay. Everyone good? Does everyone see the source sheet in the chat? Thumbs up if you do. Perfect. Okay, so let's begin. We begin with the following vignette. I'd like to hear what you have to say about it. You see that it says vignette 1, Jeanette, an ordained Lutheran minister, works as a fundraiser for her local church. Can she deduct her rent and utilities expenses? So she is an ordained minister, but Jeanette works as a fundraiser. That is what she does. Is that sufficient in order to be able for her to claim a tax deduction? Any thoughts before we look at the secular law? If you're Jeanette's accountant, will you tell her that she can deduct her utilities expenses on her house?
No.
Or,
no.
Is she solely doing fundraising, or is she doing part ministerial work, part fundraising work?
Well, I'm arguing ministerial is an interesting word we're going to have to define. That's part of the question. But I'm arguing what she does is raise money so that the church can continue promoting its religious tenets and religious exercises and its teachings.
So there's 2 separate issues here. One would be whether she was entitled to a mansing allowance if she was a pastor or a pulpit holding church leader. And the other thing is, from a business point of view, does she work from her home with no other office?
Okay, so does she work from her home? Those are both interesting. But I guess in terms of the second point, I don't mean this as a business expense. Let me be clear. What I mean is there is a specific ability for clergy members, as we'll see in just a minute, to deduct the expenses related to their place of living if they live there because of their position as
That's
a
what I
clergy
said.
member.
If she had a pulpit of some kind and she was counseling people or hosting people, for church meetings and so on in her house, then I could see it. But as a fundraiser, I don't see it other than as a business expense.
Okay, so I think what I've heard so far is that fundraising, even if you're a minister, fundraising doesn't count as a ministerial activity. That's what I'm hearing mostly. So I'm going to dispute that, and I wonder if, based on the secular law only, again, this is not my area of expertise, but it seems to me, based on the literature, that that's not true, and I wonder if you'll disagree with me after we read it inside. So let's begin with sort of the background. Where does this sort of exemption for clergy come from in secular law? So this actually was brought in a recent case in the United States where a company named, a foundation named the Foundation for Freedom from Religion, not freedom of religion, but freedom from religion, which is an atheist humanist organization, which essentially sued the government, arguing that giving ministers, religious ministers, exemptions from taxes violates the separation between church and state. And therefore, they were trying to get it revoked. It's very admirable how wonderful and lishma they are and how much vigor they have in fighting for their position. It's not okay that religious rabbis and ministers get exemptions. We want that stopped. That was their motivation. And it went back and forth in court, but ultimately they didn't win. And as we know, there still is, even in the United States, there still is an exemption from certain taxes, not on everything, but from, clergy get to deduct certain expenses from their income tax. And part of the reason for that is because this didn't necessarily originate as solely a religious deduction. If you look at source number 1, this is Judge Michael Brennan's opinion. He documents some of the history of this. He says as follows: the facts before us are not in dispute. The 16th Amendment was ratified in 1913, authorizing Congress to levy an income tax. Congress imposed a federal income tax that same year and has levied one in various forms since. As a result, Congress and the Treasury Department needed to define taxable income. A rule defining income that survives today in the Internal Revenue Code is the convenience of the employer doctrine. Under that doctrine, housing provided to employees for the convenience of their employer is exempt from taxable income. Early examples of exclusions under the doctrine include housing provided to sailors living aboard ships, workers living in camps, and hospital employees. But the convenience of the employer doctrine was not made available to ministers. In 1921, the Treasury Department announced ministers would be taxed on the fair rental value of parsonages provided as living quarters. Congress reacted quickly and enacted a statute to exclude church-provided parsonages from the taxable income of ministers. Basically, the bottom line is this wasn't specific to ministers. This was an exclusion for certain expenses related to residents for people who lived where they live because of their employer, because of their job. And originally, ministers weren't included, and then ultimately they were included as well. And I mention this because it's important to keep into context that in secular law, this exemption is an employment-based one. It's essentially, the argument is, if you are a minister and you live in a certain location, in order to perform your duties as a minister, you're entitled to deduct those expenses because you're living there for your employer and for their benefit. Okay, so I think part of the point is it didn't really start with ministers. It really started with this is a general exemption for certain types of employees that are very much based on location, and ministers were later included. So that's the history of this, and I think that's going to be important going on. So the question before us is to determine two questions. Number one, who is a quote-unquote minister in terms of this law? And number two, what is considered the type of job that a minister has to do in order to be considered ministering. And number three, what type of people or flock do they have to minister to? And those are three questions that we have to sort of define. Before I continue, though, I see a number of people just signed in. I want to remind everyone that we'd love to give everyone CPE credit for attending this class today, but in order to do so, we need you to sign in. So I would greatly appreciate it if you would email me at sbergman@torontotorah.com, or alternatively, if you can give me, if that's too difficult for you, if you can sign in by putting your name in the chat. And I'm going to, again, attach the source sheet for those who just entered. Okay, so now let's take a look at source number two, where in Canadian tax law, the parameters of this exemption are defined. So this is the Income Tax Act, and this is Section 8, Paragraph 1. In computing a taxpayer's income for a taxation year from an office or employment, there may be deducted such of the following amounts as are wholly applicable to that source or such part of the following amounts as may reasonably be regarded as applicable thereto. Okay, that's a lot of legal jargon. We're basically saying certain people get to deduct certain expenses from their income tax. Which people? That is the first part of this. Where in the year the taxpayer, one, is a member of the clergy or of a religious order or a regular minister of a religious denomination. So you need to be quote unquote a minister. That is that first category. Number two, but it's not enough to be a minister. You have to actually act and work as a minister. And how does one define that? So that's number two. You have to be in charge of a diocese, parish, or congregation. And those three words will come back later in terms of defining congregation. Keep in mind the context: a diocese, parish, or a congregation, ministering to a diocese, parish, or congregation, or, and I think this is where the fundraising idea comes in, and tell me if you disagree, engage exclusively in full-time administrative service by appointment of the religious order or religious denomination. So it does include administrative services in the types of work a minister does for this exemption. And then it talks about the amount that you can deduct. I'm not going to go into details of that. Again, it relates to living expenses, either for rental or for a place that you live in. To get to the specifics, again, you'll work that out with your clients or ask your local accountant. But that is a minister. But then there is still some degree of a lack of clarity in terms of what exactly is included in leading a congregation or being in charge of a congregation or administrative services. So for this, and again, this is U.S. law, but I do think it's a similar standard in Canada. And the U.S. law says as follows in source number 3, and I'll just one more time, let me just one more time include my source sheet in the chat for those who just joined. Okay. Ooh, not, okay, so let's look at source number 3. Except as provided in paragraph 3 of the section, service performed by a minister in the exercise of his ministry includes the administration of sacerdotal functions, okay, that just means religious, and the conduct of religious worship and the control, conduct, and maintenance of religious organizations, including the religious boards, societies, and other integral agencies of such organizations, under the authority of a religious body constituting a church or church denomination. The following rules are applicable in determining whether services performed by a minister are performed in the exercise of his ministry. Whether service performed by a minister constitutes the conduct of religious worship or the administration of sacerdotal functions depends on the tenets and practices of the particular religious body. So basically, you have to know the laws of each religious order in order to determine whether or not what the minister is doing constitutes, the function of a minister. Number 2, service performed by a minister in the control, conduct, and maintenance of a religious organization relates to directing, managing, or promoting the activities of such organization. This is what tells me that I think fundraising should be included. Isn't that what you're doing? You're managing the activities of the organization, and you're certainly promoting the activities of the organization. Any religious organization is deemed to be under the authority of a religious body constituting a church or church denomination that is organized and dedicated to carrying out the tenets and principles of faith in accordance with either the requirements or sanctions governing the creation of institutions of faith. So sort of you can look at the rest inside. To me, and again, tell me if you disagree, to me, I think Jeanette can justifiably deduct her expenses. She is an ordained minister, so she qualifies in that sense. And she certainly is working for the purpose of promoting the religious work of the church she works for. So I do think that should qualify under this statute. So again, I guess, but I think the point being that the definition of ministering to a congregation is relatively broad. It doesn't need to be literally getting up in front of a pulpit and giving a sermon or counseling. It can even include administrative activities. And that is
one quick question, Rabbi, may I ask on that? Does it matter that the administrative work that's being carried out, you'd have to have that ordination to be able to do it? It seems like since anyone could do that, as opposed to needing that ordination, it seems a bit of a stretch.
That's what I would think, but I think usually there's often a sort of gap between the purpose of the legislation and what actually applies. So I'll give you another example. I've certainly seen that people who work in music, who are musicians and play music for a church, are also qualify as long as they are ordained, even if they, any musician could theoretically do that, but it doesn't matter. The point is that the music is sacerdotal. It is involved in the religious worship. So I hear your point, and it is kind of strange that there's almost two distinct criteria here. One being a minister, two working for the religious organization, but I don't think it really matters. As long as you're involved in the administrative services, in advancing the mission of this organization, and it is a religious organization, depending on the tenets of the particular faith that it serves, you qualify.
But you could have two people side by side, where one doesn't have the ordination and one doesn't have it, and they're doing the same work, and one could be entitled to this exemption from tax. And
I think so. I think so. Yes.
Would you not look at their job description?
You might. I'm not denying that. You might look at their job description. It's very. We'll see that. Okay, this obviously gets very complicated. I can't, care to every single nuance, but in one of the cases we'll see today, that is exactly what the judge did. So it could be. But I think what you're sort of raising is that if in your job you generally have nothing to do with the church, but every once in a while you play a piano. Or in a synagogue as well, that probably won't qualify, right? It has to be part of your job. It's true, certainly.
Can I make a comment from a person who practices?
Okay,
He muted himself.
I'm sorry.
We need to get him back.
Sorry, I think you're muted. So there you go.
Can you hear me now?
Yeah.
I'd just like to make a comment because I do practice tax on both sides of the border. Just some of the differences between Canada and the US.
Right.
First thing first is, in tax, when we look for precedences, we go to Australian courts, British courts. It is very seldom that we go to US courts. Our systems are different.
Okay.
Second comment is, in the US, it's substance over form in tax law. You look at the substance and you make your interpretation. In Canada, the Supreme Court of Canada is very clear. The legal aspect of a transaction or the textual and contextual words in the Income Tax Act, they count unless it's a sham. So there is a big difference between the two systems. So I would not necessarily go and rely on US definitions for almost anything. That would be my view.
I'm not denying that. Without naming anything specific, I've heard from a friend that it's pretty broad in Canada also. But your point's well taken. That is taken from the US security and treasury laws, and you can't necessarily infer from them. But I do think, in terms of looking for in Canada also, it does seem pretty broad. In terms of defining what those terms mean, I look to that. But you're right. No, again, don't make any conclusions based on what I'm saying today. I definitely would ask a professional who is more fluid and familiar with the Canadian tax regulations. Okay, but that's our first point. Okay. What about, so let's go now, let's move a little bit from the secular law to the Talmudic law, which is more my field anyways. And I want to look at vignette 2, and I want to ask you, imagine you're David's accountant here, and I want you to answer his question both as a professional accountant and a tax professional, and also I want to look at it from a Talmudic perspective, okay? So vignette 2. David is an ordained rabbi who balances his time leading his local synagogue while running his own law firm. Okay, he does both. He's a rabbi and a lawyer. Can David deduct his hydro and gas bills from his residence from his taxable income? Would he be exempt from taxes under Jewish law? So let's start with secular law. Do you think David gets this clergy deduction? Does it matter that he also works as a lawyer?
Why not have a proportional deduction?
Proportional. Okay. Interesting. So proportional is interesting because even as a rabbi, you only have a certain limit that you can deduct, right? But okay, so you're saying proportional. Any other thoughts?
I'm just wondering whether it would be proportional as to time spent or income earned, given the how much a lawyer makes and how much a rabbi makes. So if you went proportional, you'd have to determine how you would base the proportionality.
Okay, so I think, and again, free to disagree, I would argue that he can take the full deduction in secular law. And that is because the synagogue can say that they're giving him a certain amount of money in order for him to live near the synagogue. And they can, and on that basis, he can deduct the expenses. He does totally qualify both being a minister and for performing pastoral functions. There's no doubt about that. So as long as he qualifies for that, and the synagogue says they're paying him in order for part of their salary to him so that he can live near the synagogue and work as the rabbi, I do think he can take that deduction. I don't think it matters that he's a lawyer. However, I do think it's going to matter in Talmudic law. Miriam wanted to say something?
Just a question. You keep on saying so that he can live near the synagogue, and maybe from the Orthodox perspective, I don't think it matters if he could live, let's say, downtown Toronto and have a church or a synagogue miles and miles away. The clergy residence deduction, I think, still stands if he qualifies that near the synagogue or near the church.
Right. You're right in practice. You're right in practice. You're 100% right in practice. As far as I know, at least, you're 100% right in practice. I think the theory of the law, again, was that, well, you have to live here so that you can pastor to us, and therefore that's why you get this deduction. But I think you're right in practice. It doesn't matter how close the rabbi or minister lives.
You're moving this rabbi to the city from elsewhere, right? So it doesn't have to be within walking distance, but he was in Atlanta and you're moving him to Toronto.
Right. Exactly. Thanks for that. So I think, again, I would argue from a secular perspective, totally make the whole deduction. You are a functioning rabbi. That is your job. But I think you'll see that in Talmudic law, it's much different. Okay, so let's look at source number 4. Hopefully everyone sees it. This is the Gemara in Bava Batra in the Talmud. The Gemara here is generally discussing contributions that you, as a member of a community or a citizen of a courtyard, are obligated to contribute to the greater public. That is the context of this Gemara. If you look in the beginning of source number 4, I'll just read the Mishnah quickly. So a person lives in a courtyard and shares the courtyard with a number of other residents in that courtyard. We force them to contribute to paying for a gatehouse and for a gate and door for the courtyard. And then Rabbi Sammy Bergman says, no, lo kol chayach tzero ru'u levei shar. So the argument here is everybody compelled or obligated to contribute to build a gate for a courtyard? And this is important because the argument sort of is, does everybody really need it? Does everybody really need the gate? And the argument is maybe not everyone needs to have a gate in their courtyard, and based on that, you can't compel them. I mentioned this to you to outline the fact that the contributions we'll be talking about in this Gemara are based on need. The argument is you need this too. You're a member of this community. This expense is for the entire community, and therefore you also must contribute. That is the argument here. And you have a similar notion in regard to a city. You must contribute to the wall and the door and the security measures for a city. You make you do that, even if you say, no, I don't want to, where Rabbi Shimon Gamliel says, no, it's not true. If not all cities necessarily require a wall, and therefore don't necessarily need to contribute. Okay, so that's all well and good. Then we get to this Gemara. So the first part of this Gemara, we won't read it inside for now for lack of time, asks a very interesting question. How do you determine how much every member of the city pays? Is it based on sort of how much money they have? Or is it based on just a population count? We divide it evenly, among whoever lives in the city. Furthermore, do we care how close they live to the wall? Meaning the people who live closer to the wall are obviously going to need the wall more. So again, without going into the details of that and what makes sense, and you can already start thinking about the quote-unquote taxes. These aren't truly taxes in this context, in that you're contributing to a communal fund rather than paying the government in this specific example, but you have an example of someone being compelled to contribute funds to a communal cause, and it is based on their need and based on potentially how much money they have. Now I'd like to, and I'll read it in English, now I'd like to continue with the third part of this Gemara. For those of you who are following along, it's in source number 4, and we're going to read from the third little snippet there where it says, it is related. It is related that Rabbi Yehuda Nasi once imposed payment of the tax for the wall, even on the sages, the Rabbanim. So Rabbi Yehuda Nasi comes, he says, look, everybody has to pay for this wall, we're building a wall. The rabbis got to pay too. The rabbis also have to contribute. Reish Lakish said to him, the sages do not require protection. Rabba'an lo tzrichi nitiruta. As it is written, how precious are your dear ones to me, O God. If I should count them, they are more in number than the sand. Right? The verse in Psalms describes how wonderful and how numerous the righteous are. Says the Gemara. If I should count who? If we say this is referring to counting the righteous, and the verse is saying that they are greater in number than the grains of sand, this is difficult. Now, if it is written about all of Israel as the sand which is upon the seashore, can the righteous themselves, who are a part of Israel, be greater in number than the grains of sand? Meaning, all of Israel is compared to the sand in the seashore. So certainly the righteous in and of themselves can't be more than the sand in the seashore. So that's not what it means. What does it mean? Rather, this is what the verse is saying. If I should count the deeds of the righteous, they are greater in number than the grains of sand.
Hi, Gino, it's Neil. Hi. Gino. Hi there.
And they are greater in number than the grains of sand. And it follows by a 40-year kal v'chomer. If the grains of sand, which are fewer in number, protect the shore from the sea, do not all the more so the deeds of the righteous, which are greater in number, protect them? Essentially, if the sand protects the sea, don't the deeds, the ma'asim tovim, the good deeds of the righteous, don't they certainly protect the righteous? The righteous are protected. That's what the Gemara is saying. The righteous are protected. They have a spiritual protection. Therefore, they don't need this protection of the wall. Therefore, they don't need to contribute funds to the community building of the wall. Let me preface before I continue by saying that certainly before making any conclusions about applying this nowadays, we'd have to reckon, who's righteous nowadays, and we'll get to this, and what expenses we're talking about. But at least the Gemara's argument, let's at least understand the Gemara's argument. The Gemara's argument is that there's a certain spiritual protection afforded to the righteous, and therefore the righteous don't need to contribute to the wall around the city. So before I want to take any questions, let's just see a few more examples of this in this Gemara. The Gemara continues. Rav Nachman bar Chisda Rama Kraga Arabana. Rav Nachman, the son of Rav Chisda, imposed a tax, a kraga, which here in this Davidson edition is translated as poll tax, on the rabbis. you look at the commentaries, they say a praga is as follows. The king or the government take a census of the population, and based on that census, they levy a tax on the community. And if there are more people in the community, they will charge that community more for this tax. Okay? That's what's happening. So that's what he wanted to do. Rav Nachman bar Chisda wanted to impose this tax on the sages. Rav Nachman bar Yitzchak Amar Rav Nachman bar Yitzchak Avarta adu oraita udinavi adiktuvi. Rav Nachman bar Yitzchak says to him, you have violated the words of the Torah, the prophets, and the writings by making the rabbis contribute to this tax on the population. You're violating the whole of the Bible, the Torah, the writings, and the prophets. And the Gemara continues to quote psukim to the effect that rabbis do not need to contribute to taxes. Just to give you one example of that, let's go briefly to source number 5. We have an actual very interesting reference from Ezra. And in this reference, Artaxerxes, who is king at the time, who gives permission for the Jews to return to Israel and build the temple, he commissions as Ezra Sofer, Ezra the scribe, as the leader of the Jewish community to lead this expedition. And he also says as follows, we further advise you, this is JPS Tanakh translation, we further advise you that it is not permissible to impose tribute, poll tax, or land tax on any priest, Levite, singer, gatekeeper, temple servant, or other servant of this house of God. Right? The king himself says you cannot tax these people who are engaged in this endeavor of building the temple. So this is used as a source in the Talmud to teach that it is inappropriate to tax, quote unquote, rabbanon, rabbis. Furthermore, we'll just read source number 4 before we pause for any questions or comments. Look at the last snippet I have there in source number 4. Rav Yehuda says, Hakol le'egle Gapa. Everyone must contribute to the building and upkeep of the city gates, afilu miyasmi, even orphans. Aval rabbanan lo tzrichi nitziruta, but the rabbis don't require protection. Hakol lekarye pasya, and this is a bit of a question what exactly this means. Everybody must contribute to, I'll give you 2 interpretations. Rashi says here this refers to the digging of wells. Other interpretations, like the Tosafos, argue that this refers to removing obstacles from the road. However, even the rabbis need to contribute to this endeavor of Krarye Pasha. For argument's sake, we'll say for digging wells. Below Amran el below Nafki Belchluza, Aval Nafki Belchluza, Rabbanala B'nei Mefa Belchluza Ninhu. This was only said when people are not required to go in person and dig these wells. But if the rabbis would need to contribute with their actual labor, that's considered not beneath their dignity, and therefore they don't need to contribute to the actual digging of wells. However, what we see from this Gemara is as follows. There is a general exemption for, quote unquote, the rabbis from contributing to communal funds and also contributing to communal taxes. It seems to be a pretty wide-ranging exemption. However, there is an exception for certain categories of taxes and funds which are required for endeavors which contribute to the actual livelihood. So things like digging a well. Everybody needs water, so the rabbis need water too. They also need to contribute to that. However, in terms of nitziruta, things that have to do with security, and even general taxes to the government, the rabbis don't need to contribute. What we'll have to do in a few minutes is to define what exact taxes they are exempt from and what you need to do to qualify as a quote-unquote rabbi for this exemption. But I saw a few questions. Before I do pause for questions, I just want to remind everyone that if you do want CPE credit for this class today, please email me at sbergman@torontotorah.com and let me know that you're here. Otherwise, leave a message in the chat. Or alternatively, and also if you want to be included in our email list, send me an email or leave a message in the chat as well. Yes, Marianne.
So the idea of
Hello?
can you hear me?
Now I can, yes.
So the idea of rabbis enacting a law for their own benefit. So it's rabbis enacting a law that rabbis don't have to pay taxes. There's something, that's one. And then the whole concept of saying, well, rabbis don't need to pay for the walls because the rabbis are protected spiritually. Well, I mean, like, did they not read Asara Harugei Malchut? I mean, that just doesn't happen. The rabbis are not any more protected from any sort of perils, whether they're disease or foreigners. That just doesn't bear out in fact. And rabbis who are heads of households, they have children, they have spouses, they're not the only ones that they're not paying only for themselves. So the whole thing just, I don't know, it just doesn't sound very, I don't know, it just rubs me the wrong way. I don't know, it just doesn't sound right.
I totally hear both those points. Let me be clear about that. And I think both those points are 100% on target. In terms of the first point, the rabbis writing the law for the rabbis, you make a very good argument. But it is the rabbis who are sort of in charge of writing the Talmud. So it wasn't going to be anyone else that does that. But it is a good point. It's sort of, when we read Talmud, we sort of we have a certain respect for, the rabbis involved in that they're doing it for, actual legitimate, genuine reasons, and not in trying to teach the will of God and not simply for their own benefits. But it's a good point. I'm not denying that. In terms of the protection point, so that is certainly a good point. I think that the rabbis of the Talmud did see things differently in that we do have stories in the Talmud of rabbis enjoying this unique protection and like having miracles happen to them. It certainly might point to the fact that it's certainly going to be a very specific type of rabbi. It's not going to just be anyone. But the other point I want to also mention, and this is, I think, another interesting point, is that it doesn't seem to be only related to the notion of a spiritual protection that emanates from Torah, as I think we're about to see. And that is because not all taxes are necessarily related to that. And when the government levies a tax on the people, that isn't necessarily related to protection. And so there also might be another notion here, which is that it's a general respect and reverence we have for quote unquote the Rabbanon. It's due to their spiritual stature and the fact that they're spiritual protagonists that we as a community protect them from these expenses. So I want to focus on this mostly not as a practical law that we're going to apply nowadays, but more as a window into how the rabbis of the Talmud viewed, quote unquote, the Rabbanon. What the perspective of the Rabbanon were, the rabbis. I think you'll see what I mean. Yeah.
Just want to go one step quickly back to the secular law before we leave it completely. I mean, is the rationale for having this deduction not dissimilar from allowing deductions for charitable donations, that it's just for the public good? It's good for people to have religious leaders. It serves the public well, and so that's why. As opposed, like I'm just trying to understand, because obviously it's not going to be the reasons that the Talmud gave. Why does secular law provide this deduction for religious leaders? And I'm just wondering whether it's along those lines.
That's a good question. Again, what I was arguing before was that that it actually isn't really based on that. It's actually based on the fact that it's sort of a convenience of employer idea that they live there for the employer.
That doesn't apply. Does that apply to anything else nowadays? Like, I mean, if you were brought in to work as a surgeon in a hospital, and you had to move from LA to Toronto, I don't think you'd be able to deduct your house.
It's a good question. If you look in the source number 1, it does mention a few other examples. I think one of them might be hospital workers, but sailors, for instance, who have to live near their ships.
But I'm wondering whether that still stands.
There are a few other examples. I don't know how it's applied to those examples as of yet. So I'm not sure. I think I'm not arguing that you're completely wrong, and maybe one of the reasons that ministers do qualify as one of the few professions who get this deduction is because of what you're saying, that it's certain public service. But I do think it's also very much tied to their job. And that's sort of the perspective that I think is important to keep in mind here. Okay.
So then the question is, if it's a local rabbi who gets hired and he's been living here all his life, would he be entitled to the same deduction?
Yeah, you're right. In terms of the application between reasoning and rationale for it and how it's practically applied, it's not always so smooth. So I think, yes, you would get that deduction, because even if you've been living there all your life, but you're still, if you continue to live there so that you can be a rabbi or a priest or a minister, then that still counts. You don't need to move to the synagogue or church or parish in order to do the job. As long as you're living and you're acting as that role, that's the rationale. Okay. Sorry. Let's move through some of these rabbinic sources a bit quickly outside, so that I want to get at least also to the case in the end as well. I know we're running out of time. So what does this apply to? So a few important things to keep in mind. If you look at sources 6 and 7, there's a very interesting dispute between the Ramban, the Nachmanides, and the Yad Ramah. And it goes as follows, okay? Number one, the Ramban says that this only applies to quote-unquote communal taxes, meaning a tax that is where the government is not charging each individual, but rather charging the community as a whole. Because at that point, the Ramban argues, then you could say, well, look, the rabbi or the chacham can say, it wasn't necessarily incumbent upon me. Also, it's incumbent upon everybody. And, I'm not, it does sound a bit haughty, I have to say as I'm saying it, but but you can, who says that this communal obligation should be imposed upon me also due to my spiritual status? I don't need the protection. But if it's an individual one, if the king is imposing a tax on every individual person, so then the Ramban argues, and then what's the rabbi going to say? Like, then certainly the king is charging you specifically. And then the rabbi does need a benefit. That's the Ramban's argument. However, if you look in source number 8 or source number 7, this is the Yad Ramah. The Yad Ramah disagrees. And the Yad Ramah argues, no, that the kraga, the population tax mentioned in the Talmud, was essentially a tax levied upon each individual person. And yet, the Talmud exempts the rabbis anyways. So the Ramban is incorrect to suggest that that the rabbis, the Rabbanon, the Torah scholars referred to in this Gemara, have to pay for personal taxes. Indeed, they are exempt from all taxes. However, he then proceeds to make a number of qualifications. I think this is where it gets to get very interesting. Take a look at source number 7. I'll read it in English. In the second paragraph, which begins, however, this only applies to Torah scholars who engage in Torah study constantly as best as they can, and they fulfill the mandate of you shall contemplate it day and night as best as they can. But Torah scholars that don't constantly engage in Torah study, and they don't suffice with working to earn a livelihood for themselves and their families, but rather toil to become wealthy and desist from Torah study to gather a lot of money, these people are obligated in all communal obligations. Similarly, Torah scholars who belittle mitzvot and have no awe of heaven upon their faces, they are viewed as the kalim shebetzibor, the dregs of society. The Torah said all his holy ones are in your hand. And these are the ones for whom the community suffers no punishment. This excludes those who desecrate the name of heaven publicly. So what Rav Meir Abulafia, the Rabbah, has basically said here is that this isn't just any rabbi. Number one, it has to be a rabbi who is engrossed totally in the study of Torah, in all of their spare time. He allows for some time to earn a basic livelihood, but beyond that, it has to be total engrossment in Torah study. That's number one. Number two, it needs to be that they are Yarei Shamayim, that they have fear of heaven. It's not simply a function of any job, certainly. It's not even a function of simply being preoccupied with Torah study. It also is a certain spiritual stature. They have to have fear of heaven. They have to be righteous. And furthermore, they have to be very careful in the way that they act. They have to be very scrupulous. And I think also the line at the end here is very interesting in that he says, those people can say, the community suffers no punishment because of us. In that sort of the argument is these taxes levied by the government are a punishment. And I think thinking of the context in, Talmudic and medieval times, where you have these small Jewish communities who are in control by these monarchs who levy taxes frequently, and there's no rhyme or reason to it, that they experience those taxes as a punishment, whereby the spiritual protagonists, such as the Torah scholars, say the punishment isn't because of us. And that's sort of the argument. But it's certainly, it's a very high standard of engagement in Torah study and spiritual vigor. So before I just pause for a few more questions, I just want to note, number one, if you look in source number 8, this is in the Code of Jewish Law. And as we noted, there is a dispute between the Ramban and the Yad Ramah as to the extent of how this rule exempting rabbis from taxes applies. But the Shulchan Aruch, Rabbi Yosef Karo, in the Code of Jewish Law, seems to actually rule like the more lenient opinion, that it is very applicable. It has a very broad scope. And that it applies to all sorts of taxes that don't directly relate to the basic necessities of life for the individuals in the community. And he also, though, discusses the qualifications in order to be one of these rabbis. And here, he mentions the notion of being totally engrossed in Torah, the notion of Torato umanuto, that the Torah itself is their livelihood, apart from some time dedicated to earning a basic livelihood. And beyond that, I'd like to just focus on the comments of the Ramah for a minute. The Ramah of Moshe Isserles, who was the Ashkenazic rabbi in the 16th century, who had glosses to the Sephardic Shulchan Aruch, writes as follows. You can look at the italics there. It makes no difference whether he has a yeshiva or not, only that he is considered a Torah scholar in his generation that knows how to properly converse in Torah and understands with his knowledge most parts of the Talmud, the decisions of the Gaonim, and his Torah is his livelihood, as we've explained. And he says, even though in certain terms we nowadays say we don't have Torah scholars, so there's a law indicating that if you punch a Torah scholar, you have to pay them a litra sel zahav, a certain amount of gold, which is a unique fine for a Torah scholar because you're denigrating the kavod Torah. We say nowadays that that fine no longer applies because, quote unquote, we don't have Torah scholars. In this regard, in regard to the ability, the exemption from taxes, we are lenient, and we do say that any Torah scholar who has a reputation for being an incredibly prodigious Torah mind, engaged solely in Torah study, and the Yarei Shamayim is considered a Torah scholar. They don't need to have a yeshiva. However, he notes at the end there that there are various customs in terms of whether places actually abide by this principle, and it does vary from place to place. Furthermore, I know I'm rushing a bit here, but I do want to get to the end before I run out of time. The Tzitz Eliezer makes a number of very interesting notes. The Tzitz Eliezer Waldenberg, 20th century prominent halachic decider in Israel, notes as follows. First of all, he says, age and prominence don't matter. It's not a question of ordination. You actually don't need to be ordained. He gives a proof from the notion of the term sorva mirabanan, which is discussed in the Talmud as a person who is exempt from these taxes. Sorva mirabanan actually means usually a disciple of a Torah scholar, a young Torah scholar, not necessarily the most seasoned veteran. So number one, you don't need ordination. He then also discusses the following very interesting case. What about teachers of children who get paid for their Torah learning and their Torah teaching? So he actually rules that they are not entitled to this exemption. And that is because they receive funds for their Torah learning, they're not included in the notion of Rabbanan, who are learning solely for the purpose of Torah study. And therefore, you can't say Torah umanuto, because they're getting paid, and they don't qualify. And it's based on a Ramban he found. He contrasts that very interestingly with people who learn all day, let's say in a kollel or an institution of a seminary, which is dedicated to Torah learning, and get paid for being idle. Meaning they get paid because, look, we learn Torah all day and we can't do anything else. And he also says they're getting paid for their halachic decisions that they render. Their pay isn't for the Torah itself. Their pay is for, their decisions as to whether something is permissible or not permissible. So it's just very fascinating. Before we go back to the sort of the third case, I want to just sort of summarize what we've seen from the Talmud itself. I think you've seen the Talmud as follows. The notion of the rabbi in the Talmud, in this context, number one, doesn't relate to any professional engagement. You don't need to be a teacher. In fact, it's maybe worse if you're a teacher of Torah. You don't need to be tofes b'yeshiva. You don't have to have any particularly prominent position in the community. And you might not even need to be ordained. You don't need to get official ordination. But what you do need is something else. You need to be totally engrossed in Torah learning. You need to have religious qualifications of having awe of heaven, being a yarei shamayim. And you need to actually, perform the mitzvot. It's not just an academic endeavor. You need to be engaged in keeping the Torah to the best of your ability. And you need to have a requisite knowledge of Torah. You have to know that you're familiar with the Talmud and the Gaonim and the codes and all of the important, decisions. So it's a drastic contrast that with secular law, where number one, there isn't any qualification in terms of knowledge or in terms of your personal performance. We don't go after you and look to see how you actually live your life. All we need to know is that you minister to a congregation and that you're ordained. So it's a totally different conception. And so just going back to vignette number 2, while I think the lawyer rabbi will qualify for this exemption under secular law, I do not think that this person will qualify for any exemption under Talmudic law, because they might be a very wonderful rabbi, but the very fact that they run a law firm excludes them from being the type of spiritual protagonist we're talking about. Okay, Miriam has a question. Go for it.
Okay. When we think about taxes, to a great extent, we think about income redistribution. And where we get income redistribution in Jewish law is concepts like ma'aser and leket, shichachat. Are the rabbis exempt from these halachot, which are effectively taxes? Are these the taxes also that they would be exempt from?
So it's a great question. I don't think so. No. And I think what your question again reflects upon the way that the rabbis are viewing quote unquote taxes in their time period, whereby they're like sort of these fines from the government, number one, or communal needs. And I think those are the types of taxes we're talking about. Again, if you look at the literature, it very interestingly does seem that a lot of rabbis do think this is fundamentally applicable, but I think the arguments can certainly be made that the taxes that we're talking about are of a particular character. And it doesn't, Maaser and Truma, tithes mandated by the Torah, are religious obligations mandated by God, not by the government. Although there is, I certainly should mention, a religious obligation to pay your taxes to the government. Dina de Malchut Dina, we follow the law of the kingdom, and even just contributing to the community is a very important thing. And by the way, there are also stories of many rabbis who did certainly not abide by this notion. But in terms of the rule itself, we do distinguish between taxes from the government and, tithes mandated by the Torah. So it's a great question. Okay, so we don't have that much time left, but let's briefly address the last case in the last vignette. Okay, so vignette 3 is as follows. Jacob worked as a community educator. He's paid by the community to give Torah classes and run educational programs throughout the community. However, he isn't connected to any particular synagogue. Can he claim the clergy residence deduction? So you have a rabbi that teaches lots of Torah to the community all over, but is not connected to a specific obligation. So this relates to the case you have in source number 10. And in the brief time that I have remaining, let me briefly summarize the case and where I think Torah sort of veers from secular law. The case is as follows. There are a number of rabbis, and again, I want to thank Miriam Snowbell for giving me the information on this case. There is a case where a number of rabbis from the Vancouver community who taught in the Jewish day school in Vancouver took the clergy residence deduction. But they were rabbis only in the school, not of a particular synagogue or community. They just worked in the school. They were denied their deduction. The government rejected it. And they sued and they took it to court. And their argument basically was twofold. Number one, Torah is not simply an intellectual exercise or a class that you teach. It is inherently a spiritual and religious activity. It is a worshipful, sacerdotal function that they serve by teaching Torah, and the students that they daven with, they pray with, and that they learn with constitute a congregation. And on that basis, they should also be entitled to the clergy residence deduction. Okay? The court rejected their claim, and they said, number one, the main basis, the main idea, the whole law from its inception was meant to exclude teachers in schools. So it just makes no sense to include these rabbis who taught in a day school. And the argument is you can't call the students that you teach a congregation because in context, when it says parish or diocese or congregation, right, that clearly means not just anybody you teach Torah to, it means a specific group of people that you are pastoring to. I want to focus very briefly on the first question. Is teaching Torah, quote unquote, a religious spiritual activity? And to be honest, you can look at the source sheet. I don't think they argued this very well, but I'm actually fascinated, almost astonished by the comment. I'll just read you the comment of the judge. He says, while you look at source number 10, while Torah is, we're under that heading, no consensus on the spirituality of Torah education. While Torah is undoubtedly important in the life of an Orthodox Jew, the rabbinical court's assertion that Torah education is more than an intellectual pursuit and that it is in and of itself a spiritual engagement akin to prayer or other rituals does not hold up under close scrutiny. Right? The argument is Torah learning is not in and of itself a spiritual endeavor. It is simply educational. That's how it seems to me. I would argue vociferously against this notion, and I think it relates to our two portrayals of the rabbi. The rabbi in secular law is doing a job. And the teacher in secular law is teaching children. In Judaism, Torah isn't simply education. The rabbi is, as seen in the Gemara, as a spiritual protagonist who has to have fear of heaven and have a mitzvah performance. And let me just demonstrate to you that to you very briefly. If you look in, I'm sorry I have to run so quickly, Maimonides, in his laws of studying Torah, mentions how learning Torah requires sacrifice, requires detaching oneself from the physical world. It requires humility, right? Would you ever say that studying another pursuit, it might help you learn better? Would you ever say that it requires humility? Furthermore, the Rambam says in the laws of teaching Torah, if you look at source number 12, in chapter 4, the first halacha, we don't teach Torah unless the student is fit and pleasing in his actions. However, if he walks a path which isn't good, we return him to the good and lead him on the straight path. We then check him and only afterward bring him to the study hall and teach him. You have to have a certain character in Jewish law to even qualify to get into the Torah classroom. And could you imagine such a character being required for, simply learning an intellectual pursuit, engaging in any other discipline? Furthermore, just the Balatanya, the first of the Rabbis, the Rebbeim from Chabad, argues that Torah learning is in meeting and a union between our mind and the mind of our Creator. That's what it is fundamentally, that the Torah is the will of God. It's not simply interesting Jewish knowledge, it's the will of God itself. And when we contemplate and analyze the concepts of Torah, our mind is encompassing the will of God and uniting with it in the most direct union that you can have with God. So I know I just argued that very briefly, but I would argue essentially twofold. In terms of their argument that Torah is not a spiritual endeavor, I don't think that that's actually a good argument at all. I think Judaism clearly does see Torah as not just something that you're learning intellectually, but definitely a spiritual endeavor, which requires character refinement and requires humility and total dedication to the cause. And I think that argument really could be made in court. In terms of the congregation argument, however, that I think does sort of depend on the context. And I think the argument that, look, in the context of the law, a congregation isn't simply people you teach to. It is, a religious community akin to a parish or diocese. So again, ultimately, in Vignette 3, you probably wouldn't get the secular tax, deduction. If you're a teacher in a school, you don't get the clergy tax deduction, even if you are a minister and you do teach Torah. However, I do think it points to this difference that we have between the Jewish and Talmudic version of the rabbi or Torah scholar and the secular vision of the rabbi or pastor, whereby in secular law, it's a wonderful thing, but it's sort of a professional function. It's an occupation that you serve, whereas in Jewish law, it's much more than that. It's a preoccupation. It's a spiritual endeavor. You have to become this sort of spiritual protagonist and have total dedication to the cause of imbibing the will of God. Okay, so we'll stop here. I know I'm a little bit over time.